Hello everyone, Jai Hind and welcome to the platform of StudyIQIAS in English, and my name is Bhanwarsingh. I'm ex-NDA 115th course, qualified civil services in 2012, and I welcome you all on the platform. So let's see who is live right now with us. If you are live, please type in the message and let me know that you're watching this session live along with me. All right, now as you all know that we are covering all those important things from which nearly every year UPSC asks the questions. And again, moving ahead in the series, today we'll be discussing the landmark Supreme Court judgments that were delivered by the Supreme Court and ultimately how they will be asked and what all is there in the complete judgment that we'll be seeing in today's session. At the same time, till your prelims, we will be holding the marathons as well. There will be marathons that will be conducted on all the platforms of StudyIQIAS. So you may watch the marathons as well because they are again very important, because in those marathon sessions you will come to know about what different type of questions will be asked in your upcoming prelims. So these are the initiatives that we are taking so that you qualify your prelims and ultimately you achieve your dream to get the service as an administrator. Now, like I said that today we'll be covering the landmark Supreme Court judgments and even the recent Supreme Court judgments that had been there, and total there will be more than 40 of the judgments that we will cover. Now, when it comes to the priority, so you must understand that when it comes to the judgments, so earlier there were lots of judgments that were, that are the landmark judgments that were given by the Supreme Court and you must know about them. Like for example, Keshwanand Bharti case. In this case, the basic structure doctrine was laid down by the Supreme Court. Then the Menka Gandhi case where the due process was expanded under the Article 21. Then S.R. Bomai, again very, very important because it deals with federalism as well as the president's rule as well. Then Indira Sohani case in which the ceiling on the reservation was provided and 50% ceiling was decided by the Supreme Court along with extension of the reservation that was given to the other backward classes. And again, very important is K.S. Puttaswamy case in which the right to privacy was declared as the fundamental rights. Now, these are the most important cases that you must master while you are preparing for or you are going forward and you are sitting in the prelims 2026. At the same time, when it comes to the UPSC tests you for these cases as well. There is Minerva Mills case. There is another case that is Ayar Kaulo and Navtej Johar. All right. At the same time, when it comes to the, economically weaker sections, so there is another case that is of the reservation that was provided to economically weaker section. Shaira Bano case is also very important. Then when it comes to the disclosure, all right, there was a case in which the Supreme Court have said that the candidate disclosure is very important and the candidates who are, who are contesting the election, they have to disclose their criminal proceedings which are going against them as well. All right, again, related decisions, they are again in the focus for the UPSC and you will be asked about them whenever such kind of, court judgments they come. At the same time, there are also environmental principles which had been shaped by the Vellore judgment, by MC Mehta cases as well as by Goda Varman case. Again, they are very, very important. So which are the most important cases, the landmark cases that you must understand and you must go through? Now, the first of all, it is about the electoral reforms. Now, again, we know that recently the state elections had been conducted and therefore these cases, they become very important for the UPSC perspective. All right, the first and the foremost landmark case when it comes to the electoral reform is the case of that is Association for Democratic Reforms or ADR. This was in 2002. And here Supreme Court have said that the voters have the right to know about the candidate who is contesting the election, the background, the assets, the liabilities, as well as his education details. So these are the things that a candidate, about the candidate that a person must know, and thereby it laid down that there should be a complete disclosure of the candidates whenever a candidate is contesting the election. And Supreme Court said that this is the right to know is basically where a person is, casting his vote. So therefore, he has right to information, which is again inherently there in Article 19(1)(a). And we know that RTI Act, that is Right to Information Act, is also inherently given by the Supreme Court by the Article 19(1)(a), that is right to freedom of speech as well as expression. Then there is another case, that is PUCL, and this case was in 2003. Over here, what Supreme Court did was that it reinforced the voter information rights and linked the disclosure to the free and fair elections that we have in the country. Then in 2013, Lily Thomas case was there, and it led to the decision by the Supreme Court that there will be immediate disqualification of the convicted legislator on the specified grounds. All right. So if any of the legislator who was there in the seat and he is convicted of 2 years or more than 2 years, then he would have to leave his seat. And this was decided by the Lily Thomas case in 2013. Again, very important for your upcoming examination. All right, so it is very, very important. And at the same time, when it comes to the public interest litigation, the line on the criminalization as well as political accountability, and this all keeps the complete issue alive when it comes for the UPSC, and UPSC links these of the important case decisions that were taken by the Supreme Court. And again, it is very important because recently we had the elections in the state assemblies. All right. Now, when it comes to the fundamental rights, these are again important landmark judgments related to the fundamental rights. The first one is A.K. Gopalan case. So in A.K. Gopalan case, Supreme Court, it took initially a narrow point of view, and over here it compartmentalized the view of the rights of or the fundamental rights that are given in the Constitution. But later on in Maneka Gandhi's case, it had transformed the everything when it comes to the Supreme Court. So over here in Maneka Gandhi case, it said the Article 21 is, ultimately it is where we have to insist upon the fairness, upon the reasonableness and the non-arbitrariness of the complete institution. All right, Article 21 that lays down for the right to life as well as personal liberty. So over here, there were two things. All right, there is due process of law that was justified by the Supreme Court when it comes to Maneka Gandhi case. And after Maneka Gandhi case, you will see that when it comes to the Supreme Court, Article 14, Article 19 as well as Article 21, they were read together in most of the liberty cases that are there. Then when it comes to a very important benchmark in the constitutional history of India, we have Keshwanand Bharati case. Now, Keshwanand Bharati case is very important because this was a judgment, and when it comes to the complete bench of the Keshwanand Bharati case, this was the largest bench of the Supreme Court that gave this or pronounced this judgment, where it led to the lay down of the basic structure doctrine. And that is that the Parliament, it does not have unlimited amendment powers that are there. The Parliament, it could not amend the basic structure that is there. Again, you have to note that when it comes to the basic structure, so the basic structure is not actually defined by the Supreme Court. Now, basic structure is a kind of evolving perspective, and through the later on judgments, Supreme Court have clarified which all could be the parts of the basic structure doctrine. All right, then again, Minerva Mills case, it has restored the balance that is there between the fundamental rights and the directive principles. So this is again very, very important for your upcoming prelims examination. Now, when it comes to fundamental rights, there are certain rights which have evolved by the Supreme Court. Or you can say that these are the modern rights that had been granted by the Supreme Court. The first and the foremost is the K.S. Puttaswamy judgment that was there in 2017. Now, through this judgment by Puttaswamy judgment, the right to privacy or the privacy was recognized as a fundamental right, and it was said that the right to privacy is basically it is rooted in liberty, it is rooted in dignity as well as autonomy as well. Now, the next important case is Navtej Singh Johar case in 2018. Now, this was a case where the consensual same-sex relationships, they were decriminalized, and there was constitutional morality that was emphasized by Navtej Singh Johar case. Then again, when it comes to the rights of the Muslim women, so there was the case in 2017, that is Shaira Bano case, and through this case, again, it is very important, a landmark case, because through this case, triple talaq that was invalidated, and the gender justice was reinforced when it comes to the Muslim women. All right, and also when it comes to Joseph Shine case in 2018, over here the adultery law was struck down as unconstitutional and even paternalistic. So again, these are the important cases when it comes to the modern rights which are there. Then when it comes to the federalism, in the terms of the federalism, you will see that S.R. Bommai is the most important case when it is about the federalism. It was in 1994, and over here, the Article 356, that is, Article 356 is about the President's rule. Alright, it is President's rule, and over here, when it comes to S.R. Bommai case, it was said that when it comes to the use of the Article 356, there could be judicial review that could have or that could happen. And the central government, it cannot arbitrarily, impose the president rule in any of the state. So again, this is a major curb that was there on the arbitrary powers of the central government. As well as this also laid down that the floor test principles had been emphasized in the S.R. Bommai case. And again, this is very important when it comes to your upcoming prelims. State government, they cannot dismiss the governments or the state government casually on the subjective political grounds after the Bommai. And this has turned the complete tide that we have seen in the Indian political atmosphere. Because before this, what used to happen was that the usage of 356 was in the hands of the central government. The federalism was recognized as a part of the basic structure again in this case and a broader constitutional disclosure. And again, when it comes to the recent center and state disputes, that keeps the Bommai relevant. And again, you could be asked a question about it indirectly in your prelims examination. Now, another burning case or another burning topic that we have is the reservation that is there in India. Alright, when it comes to reservation, reservation is the positive discrimination that our constitution allows. It allows that there could be special, provisions that could be there for the people who are from the backward classes or the people who are from scheduled castes, scheduled tribes, as well as the socially and economically weaker sections that we have. Alright, now when it comes to the reservation, there is very important case that is the Indira Sohani case, and it was in 1992. Now this case, it upheld that there could be the reservation that could be provided to the other backward classes in principle, but at the same time, it disallowed the reservation in promotion in that ruling as well. Now this disallowance in promotion, that was for the OBC grades or the OBC class, and at the same time, it also led to the formation of the creamy layer as well. Alright, at the same time, we have M. Nagaraj case. It dealt with the conditions for the reservation for the scheduled caste, scheduled tribes in the promotion, and also when it comes to Janhit Abhiyan, it is also very important case when it comes to the reservation, because the verdict or the 103rd Constitutional Amendment Act that provided with the economically weaker section reservation, that was upheld in this Janhit Abhiyan case. So reservation jurisprudence, it often requires that there is a linking to the equality with the substantive justice, and ultimately this had been upheld by the Supreme Court in the previous judgments. Now another, when it comes to the judicial activism, so there is a sphere where we have seen that there were lots of cases that dealt with environment. Alright, there were lots of cases, and these cases, important one are the cases which was filed by MC Mehta, and these are series of cases where this has expanded the environmental governance and even the public interest litigation in the terms of environment in India as well. Alright, there is also another important case, that is Vellore Citizen Welfare Forum, which have recognized that there is a precautionary principle, and even when it comes to the principle of the polluter pays, that is recognized, or that was recognized in the Indian environmental law. Alright. At the same time, another important case is T.N. Godavarman case. Now, this have reshaped the complete definition of the forest in India. Alright, and even after the change of the definition, the forest governance and the continuing of the mandamus practice was also shaped by the Supreme Court. So again, T.N. Godavarman case again becomes very important. And also there is Indian Council for Enviro Legal Action. This is another key case when it comes to the environmental liability, and through this, it was laid down that the polluter pays and absolute liability lies with the polluter. These were the principles that were laid down by the Supreme Court in these important cases. Now, at the same time, when it comes to the Supreme Court have also given judgments that deals with the judicial review as well. And when it comes to judicial review, the most important one is Keshwanand Bharti case, because over here it was held that the judicial review is the basic structure of the constitution and it cannot be taken away from the Supreme Court or even from the high courts. All right. At the same time, our Kaulo case is also there, where the laws which were placed in the 9th schedule. Now, 9th schedule was used by the government as as a proxy. It was used as a proxy because whatever the laws or the judgments the government wanted to be shielded from the judicial review, they used to place it in the 9th schedule. Because 9th schedule, it was practically the schedule where the judicial review could not apply. But in our Kaulo case, what happened was that it was laid down that the laws which are there in the 9th schedule, and if they are placed after the judgment of Keshwanand Bharti case, all right, that is in 1973, so ultimately they will be or the judicial review, that will apply on those laws, and those laws will not be immune anymore. All right, so ultimately again this is a very important case, and we have seen the NJAC case as well. That is National Judicial Appointments Commission case, where again judicial primacy was reaffirmed in the appointments and the independence of judiciary was a major concern that was there. All right, because when it comes to NJAC, so over here what had happened was that we have separation of power. All right, when it comes to separation of power, we have legislature, executive, which cannot have any impact on the judiciary, and that is again a basic structure that we have in the constitution that is there. And again, because of this, the NJC was struck down. Then we have L. Chandra Kumar case as well, which preserved the power of the constitutional courts. All right, what had happened was that the tribunals, the orders from the tribunals, they could be challenged in the High Court or in the Supreme Court. That was laid down by L. Chandra Kumar, and again, this is very important case that had happened. So these are the important cases, the landmark cases which happened in the history. But what about the previous year or the whole year, that is from May 2025 to May 2026, which are the important cases which you need to go through? All right, now when it comes to these cases, let's discuss these cases as well, because these are important, and we have seen that the UPSC asked the questions from these cases. Now the first one is M.K. Ranjit Singh versus Union of India. Over here there is the birth of the right against the climate change. Now till now, Supreme Court have given the right to clean environment. All right. This is different from right to clean environment, because this is the right against the climate change, and Supreme Court recognized that the Constitution confers the specific right, that is right to against the adverse effect of the climate change. Now ultimately, when it comes to the right against the climate change, this is broader right. All right, this is broader, this is distinct from the earlier right that it had laid down the right to clean environment. Now this links the Article 21, that is right to life and personal liberty, also Article 14, that is equality. And both of these articles, they had been underpinned by the directive principle of state policy, that is under Article 48A, and even the fundamental duties, that is under Article 51AG, that relates to the environment. And that is why Supreme Court said that a person and every person have the right against the climate change. Now, this case have arisen, or it has arisen from the environmental or the existing threat that the Great Indian Bustard or the GIB had been caused by the overhead power lines in its habitat, and Supreme Court said that these overhead power lines, they have to be underground. All right, and again, this is very important case, M.K. Ranjit Singh, where the question could be asked about the GIB or Great Indian Bustard, and even about the right that had been conferred by the Supreme Court. Now, the next important case is State of Punjab versus Davinder Singh. Now, in State of Punjab versus Davinder Singh, what happened what was done was that the Supreme Court decimated the homogeneity myth in the scheduled caste and the scheduled tribe reservation. Again, very important judgments where there was a 6-1 majority ruling in the 7-judge constitutional bench, which had overruled its previous judgment that it gave in E.V. Chinnaiya case. All right, over here, it had declared, the Supreme Court have declared that the state government, they are constitutionally empowered to create the sub-classifications. They could create sub-classifications within the scheduled caste and the scheduled tribes for preferential reservation benefits. All right, when it comes to the presidential list, the president, the president publishes the list of the scheduled caste under Article 341. So, the Supreme Court said that this list that is published by the president, it serves only to identify the caste that constitute the scheduled caste territory or the category. All right, at the same time, it also says that there should be substantive equality that should be provided. When it comes to the scheduled caste, Supreme Court said that there are certain of the people who have taken the benefit of the reservation, but there are certain classes as well, the sub-classification as well, which have not been given the benefits of the reservation. So therefore, over here, Supreme Court said that the sub-classification can be done when it comes to the scheduled caste or the scheduled tribe for giving that substantive equality to them. But at the same time, this sub-classification, it must be justified by the quantifiable as well as empirical data regarding the inadequate representation and the relative backwardness of these sub-classification of the that will be done. All right, the next important case is the Vanashakti recall. Now, what happened was that over here, the Supreme Court have recalled its previous judgment. Again, very important because this deals with the environment. All right, over here, the Supreme Court have prioritized the economic continuity via the principle of proportionality. Now, what happened was Supreme Court earlier gave its judgment, and in the previous judgment, it had struck down the Ministry of Forest, Environment, Forest and Climate Change notification, which allowed for the ex post facto clearing or the environmental clearances that were given. Now, over here, Supreme Court have said that this earlier judgment was to be per incuriam. Now, what is per incuriam? That is that it was delivered in ignorance of the binding law. Now, what Supreme Court have laid down over here is that the bench have emphasized that the principle of proportionality is there, and ultimately there are the industries which have invested heavily. All right, they have already invested in thousands of crore rupees, and if the ex post facto environmental clearance, they will be discontinued, so that will have a devastating impact for the public interest. And there it laid down the precautionary principle, and that is the prior approval or mandates the prior approval. The court have held that there will be retrospective election, the clearances that were given, environmental clearances, they can be granted sparingly, but only as an exceptional measure. It will be only exceptional measure, and provided that these companies will be fined heavily. There will be heavy penalties as well as mandatory ecological restoration that these companies will have to do, these industries will have to do, and then only the environmental clearances that could be given after the setup of the industries or ex posto electoral. Still my mind is in the complete election that has occurred. So, ex posto environmental clearances that can be given only after there is precautionary principle that had been followed. All right, the next one is the Section 6A of the Citizenship Act of 1955. The Supreme Court have held that this is, right, or it had upheld the Section 6A of the Citizenship Act 1955, and over here it has taken the rationality of the 1971 cutoff. Now, when it comes to Section 6A of the Citizenship Act, this basically deals with the Assam. Over here, it has said that the five judge benches, it has said that the constitutional validity of the Section 6A is right, and it grants the citizenship to the migrants who have migrated or entered Assam from Bangladesh before 25th March of 1971. Now, the provision is over here that the complete provision of 6A, it was added after the 1985 Assam Accord. And there are two categories, that is, who have arrived before 1966. Now, they are actually deemed citizens of the Assam. But those who have arrived between 1966 and 1977, or 25th March of 1971. So these people who have entered Assam from Bangladesh, they must get registered and ultimately wait for the 10 years, after which they will be provided with the voting rights, and that is what Section 6A of the Citizenship Act it stands for. Now, again, when it comes to the presidential reference, so there was the 16th, this was the 16th presidential reference that was there, and in this presidential reference, what was asked? It was asked about the powers of governor, that the powers or the how much the or if the governor have the right to withhold the assent to any of the bill that had been passed by the state legislature. Now, over here, there is that the condition of limited mandamus was put forward for any of the gubernatorial or the inaction by the governor while giving the assent to the bills. Now, what had happened was that Supreme Court have clarified that the governor's discharge of function that is available under Article 200. Under Article 200, it is basically that the governor, he has options. And what are the options? The options are either he can give the assent to the bill, he can give assent to the bill, or he can he can also reserve the bill for the president as well. So the options that are there, or a discharge of the functions which are there under the Article 200 that is given to the governor, they are generally not justiciable. Alright, whether the governor is giving the assent to the bill or he is reserving the bill for the president. So that cannot be tested in the court of law. But at the same time, any kind of prolonged or unexplained and even indefinite inaction that is subjected to judicial review and judicial intervention, that is what the Supreme Court have laid down. So over here, the limited mandamus was laid down. Alright, the main important thing is that limited mandamus was laid down where the court could direct the governor to act within a reasonable time frame on the bills which had been passed by the state legislature. Please remember over here that there is no absolute or the pocket veto that exists for the governor that was laid down by the Supreme Court, and the governor's exercise of the discretion that is also not justiciable. Another important case is of Harish Rana versus Union of India. Now, when it comes to this case, over here, the euthanasia as well as the recognition of CANH, that is clinically assisted nutrition and hydration, they were treated as the medical treatment. So that was where this the complete case it revolves around. Now, when it comes to the Harish Rana case, so what has happened is that over here, Supreme Court have expanded the horizon of right to die with dignity. Alright, over here it has said that earlier, when it comes to the earlier judgment in Aruna Schonborg case, okay, again very important judgment that was passed by the Supreme Court. This is Aruna Schonborg case. In Aruna Schonborg case, Supreme Court laid down the principle of passive euthanasia. There are two kinds of euthanasia, that is active, which is where there is injection of any lethal drug and that leads to the death of the patient. That is active euthanasia. And passive euthanasia is where the life support system is, it is taken out and ultimately a patient dies because of this. Now, when it comes to the passive euthanasia that was laid down, or the principle was laid down in Aruna Schonborg case. In Harish Rana case, what had happened was that the right to die with dignity that was expanded by permitting the passive euthanasia for a patient who was in a permanent vegetative state. Alright, he was in permanent vegetative state for 13 years. Here, court have held that any kind of clinically assisted nutrition and hydration that is being delivered through the PEG tubes, that is a medical treatment rather than the basic primary care. And over here, what can happen is that the CANH can be withheld or withdrawn if the medical experts, they determine that the condition is irreversible. Now, the same thing, this has, or the complete judgment, it has reversed the findings that the Supreme Court had in Aruna Schonborg case. Because in Aruna Schonborg case, Supreme Court, it denied that the clinically assisted nutrition as well as the hydration that cannot be taken out, or that cannot be stopped, or it cannot be withheld. So ultimately over here, the scope of the passive euthanasia had been increased. All right. And also when it comes to the continued intervention, that does not serve the patient's best interest, and that is what Supreme Court laid down in its judgment in Harish Rana case. Now, the next one is, or next important case is Pragya Prasoon versus Union of India. Now, over here, it is very important that Supreme Court said that the digital access is a constitutional imperative. In this case, the Supreme Court recognized that the digital divide is, or it acts as a barrier to the fundamental freedoms which are there, and the court declared that the digital access is basically an imperative right that is there under Article 21. That is right to life and personal liberty. It also issued a series of 20 directions that were issued for the government so that they could make the digital KYC processes, banking services, and even the government portals which are accessible or which should be accessible for the person with disabilities, including those which have the visual impairment and the acid attack survivors as well. And this is the first time that the Supreme Court have laid down that digital inclusion has been, or it is directly linked to the right to dignity. All right. So again, it is linked to, or it is inferred or imperative right under Article 21. That is what Supreme Court have said in its judgment. Now, another important judgment that was there by the Supreme Court was All Judges Association. In this, it was important because it had restored the professional rigor in the judiciary. Now, over here, what had happened is very important, all right, that the Supreme Court have said, over here, the Supreme Court have said that there will be a minimum of 3 years of the legal practice at the bar for the eligibility for being appointed in the civil judge or junior division entrance examination. Now, let me tell you about this, that this is right now, the Supreme Court is reviewing it. It is under the review, and this is under the review that is going on right now. All right. So, this has been decided, but at the same time, it is under review that is going on. In the another matter that was earlier in Rajneesh KV versus K. Deepa, the court have laid down that the judicial officers, those who have combined experience of 7 years, that is bar plus bench experience, they will be eligible for the direct recruitment as the district judge under Article 233. So over here, both the judgments, whether it is the judgment in All India Judges Association or in the Rajneesh KV versus K. Deepa, these judgments, they seek to enhance the quality of the adjudication that is there in the subordinate judiciary, and also it handles, when it comes to the subordinate judiciary, this handles the most of the country's litigation that we can see. All right. Now, coming to the next important judgment that we have over here is, this relates to the right to vote. We have seen that Supreme Court in its various judgments, there were cases that were, or that went to the Supreme Court about the status of the right to vote because of the SIR process that is going on, or the special intensive revision that is going on right now. So when it comes to the right to vote over here, there was a transition that we can say from statutory to the fundamental right advocacy for the fundamental rights in India, because of the election process, because of the SIR process that the country was witnessing. Now, there are historical precedents that we have, that is NP Ponnuswamy case and even Kuldeep Nayyar case that is there. And here, the Supreme Court have laid down that the fundamental right, the right to vote is basically a statutory right and a legal right. All right, now over here what had happened was that there was mass voter deletions and also arbitrary disenfranchisement, and ultimately over here the people, they have tried to get or elevate the right to vote into the fundamental rights category under Part 3. But the court, it had said that there are two different rights, the right to vote and the freedom of voting. All right, when it comes to right to vote, it is basically a statutory right under Article 326. All right, and when it comes to freedom of voting, it is the expressive act that a person do. All right, right to express is basically under the Article 19(1)(a). So therefore, when it comes to freedom of voting, that is a fundamental right. But when it comes to right to vote, it is basically a statutory right. That was the position that the Supreme Court had taken. Now, the next important judgment that happened in the Supreme Court relates to the Election Commission of India's independence and also the Article 324 that is there. Here, the Supreme Court have scrutinized the independence of the Election Commission of India. Right now, when it comes to this particular decision, so what had happened was that there is the act that was passed by the government, and that is Chief Election Commissioner and Other Election Commissioners Act 2023. Now, by this act, what had happened was that the Chief Justice of India, who was the part of the selection of the Chief Election Commissioners and the Election Commissioners, the CGI had been excluded from the select committee or from the selection panel. Now, over here, again, it is very important that Supreme Court is still examining the complete issue. All right, it is currently examining if the act violates the constitutional principle of the independent and impartial election authority that had been established by the previous judgment in Anup Bhanwar versus Union of India in 2023. So over here, immediate stay had been declined by the Supreme Court, but at the same time, court have upheld that the Election Commission have the plenary powers which are there under Article 324 to conduct free and fair elections in India, which also includes the transfer of senior officials during the poll time. And it also emphasized that there is unchecked power which is alien to our system, that any institution that is there in our system, there is a check on the power that remains. Alright, so again, this is what has happened related to the Electoral or the Election Commission of India. Now, there is Waqf Amendment Act 2025 that was passed by the Parliament as well. Now, related to this Amendment Act, there were lots of petitions that were filed in the Supreme Court, and what Supreme Court did. Supreme Court balanced the secular governance with the religious autonomy. Here, Supreme Court delivered an interim judgment in the petitions that seek or they have sought a blanket stay on the Waqf Amendment Act of 2025. And here it has said, while it has refused a journal stay, it has stayed the section 3R of the Waqf Amendment Act that was passed, and this section 3R, it mandates that a person must practice Islam for at least 5 years before creating a Waqf. Now over here, the Supreme Court said that there is no verification methods or mechanism that a person have practiced Islam for like 5 years before creating a Waqf. So again, this is something that cannot be justified. Also, court have upheld that there could be or there will be mandatory registrations of the Waqf and the requirement that only owners which have dedicate property, aiming to resolve long-standing disputes regarding the protected monuments and the tribal lands, they will be or they are being declared as Waqf is right in the Amendment Act. Alright, the next important judgment that happened in the Supreme Court is the Kalyani Transco versus Bhushan Power and Steel. Now in this, what had happened was that Supreme Court resolved the conflict between IBC and ED, that is the Insolvency and Bankruptcy Code and the Enforcement Directorate. Now over here, what has happened was that there was a resolution application under the Insolvency and the Bankruptcy Code, and the Supreme Court ruled that any company that had been revived through the resolution plan, alright, what happens is that if any company gets insolvent, so after getting insolvent, there are the Insolvency and Bankruptcy Code that applies to that particular company. And there could be two things. The first thing is that there is a revival of that company that happens through a resolution plan. Or if it cannot be revived, then the company, the liquidation of the assets that happens, and then the people who have the, debt over the company, they are repaid through that liquidation. So over here, what the Supreme Court said that if any company had been revived through the IBC code and that is through a resolution plan, should not be penalized for the past illegalities of its former promoters. So once a resolution plan is approved and implemented, so automatically the assets of the company should be immune from the attachment by the agencies like, for example, Enforcement Directorate for the sins of the previous management, and ultimately this provides that there will be a clean slate protection. That is, if a company after the IBC proceedings All right, after the insolvency proceedings, if there is a resolution plan and a company is revived through the resolution plan, so that means that company is now clean. And that clean state protection had been provided, which is very important for the success of the IBC code and even the ease of doing business in India. Now, the next important case that was decided by the Supreme Court is Padi Kaushik Reddy versus State. Now, in this case, there had been guardrails that had been provided for the speaker's discretion. Now, again, it is very important because this deals with the 10th schedule. All right, this is again very important because 10th schedule was in the news. All right, so over here, it is very important to note that anything that has been in news and it connects to any of the Supreme Court judgment, that becomes automatically important for your upcoming prelims. So over here, the Supreme Court have placed a critical guardrail on the speaker discretion that is there in the 10th schedule. That is for the anti-defection law. And it says that while the speaker has the primary authority to decide on the disqualification petitions, all right, the speaker has the primary authority, the chairman has the primary authority depending upon the house. So in Lok Sabha or State Legislative Assembly, it is the speaker. But at the same time, when it comes to the Rajya Sabha or State Legislative Council, it is the chairman. So they have the primary authority to decide over the disqualification proceedings or the petitions. But this jurisdiction is not immune from the judicial review if there is a tolerable exercise of power or any kind of inordinate delay that defeats the purpose of the law. Now, this is very important because it signals the potential end to the inaction of that is basically taken by the speaker or the chairman when they are protecting the defecting members of the ruling party. All right, like for example, we have seen that there had been 7 of the members from the Aam Aadmi Party who have joined the BJP. Now, if there will be an petition that is about the defection of these parties, so now the chairman of the Rajya Sabha will have to decide. Earlier, what used to happen was to protect the ruling party, they used to sit and they do not used to take any action. And that is what had been reversed by the Supreme Court by this particular judgment. And again, this is very important once again because anti-defection had been in the news in the previous times. The now next important of the judgment is Gayatri Balaswamy versus ISG Novasoft. Now, this is very important because it limits the limits of the modifying arbitral awards had been discussed over here. And it says that the 5-judge bench, it had held that the appellate courts, they have limited power when it comes to modifying the arbitral award that has been provided or it has been, there under the section 34 of the Arbitration and Conciliation Act. Now, here the court have ruled that the courts, they cannot conduct a merits review or rewrite the complete award because this has been, reached after a proper arbitration that had been conducted. So they possess the power to vary or modify it to correct the computational or any clerical or manifest errors, but do not have the power to completely modify the complete arbitration that have happened. So over here, the court have distinguished that this is different from the power of the Supreme Court that is there under Article 142. Now, Article 142 that is there, it gives the special powers to the Supreme Court. And over here, Article 142, it can be used sparingly, but only to do the complete justice. This is exceptional power that the Supreme Court gets through Article 142. The next important judgment that happened in the Supreme Court is Sanjabij Tari versus Kishore S. Borkar. Now, in this judgment, what happened was there were guidelines for the check dishonor pendency that were laid down. Now, when it comes to the pendency of the check dishonor cases, they are mounting. All right, there was an act that was introduced, that is Negotiable Instruments Acts or NI Act, and ultimately when it comes to the check bounce, earlier it was not a crime, but now it had been included under the criminal categories and the case can be filed if any check gets bounced. Now, it says that there is staggeringly high of the pendency of the cases when it comes to the check bounce cases, and Supreme Court have issued extensive guidelines under the Negotiable Instruments Act. Alright, now what will happen? So it had clarified that a signed check, it carries a legal presumption of being a valid debt. Alright, if I am giving a check to someone, I have signed that, so ultimately it is a presumption that there is a valid debt that is there. And this shifts the burden of proof to the drawer, that he has that debt that I have to repay him. And bench have noted that there is the primary goal that is there when it comes to section 138 of the NI Act or the Negotiable Instruments Act, and this is to ensure that there is the credibility of the checks which are there and ultimately facilitate the commercial transaction rather than just a retribution that is there. Alright, so this is again important when it comes to the important judgment that was given by the Supreme Court. Now again, these are some of the important judgments which had happened in the past 1 year. Again, they are very important because they touches the various fundamentals of the constitution or the sub-theme when it comes to the legal regime. So we have SV Union versus Union of India that happened in 2026, and it is where the Supreme Court have allowed the termination of a 28-week pregnancy for a minor and ultimately it prioritized that there is women autonomy over the paternalistic state interest. So this is very important because it links to Article 21, that is right to life and personal liberty. Then we have Satyan Naravur versus Union of India, and here the Supreme Court have held that the incarceration does not dilute the right to dignity. And ultimately the prevention, Disability Act or the Protection, the Person with Disability Act of 2016 that applies to the custodial settings as well, that is in the custody, in the jails. They should have the ramps as well as the toilets which should be friendly to the person with disability. The next important case was Singh versus Consolidation Officer, and over here the Supreme Court have ruled that the SDOs, they cannot change the land category. The land category can be changed only by the state government and not by the SDO, and they are reserved for, if they are reserved for the public utility. So again, this links with the 7th schedule that we have in our constitution. So again, this is very important. Then comes the Union of India versus Rohit Nathan. Over here in Rohit Nathan case, Supreme Court have let down that the parental salary alone, it cannot determine the creamy layer status for the other backward classes. Alright, there is the post as well as status and the historical disadvantage that must be assessed while we are assessing the other backward classes. Again, it links to the Article 16(4) that provides to the reservation to other backward classes as well. Alright, the next one is the Hamsa Nanduri versus Union of India. Now over here the Supreme Court have struck down the 3 month of the age limit. The 3 month of the age limit that was for the adoptive children to qualify the mothers for the maternity benefits. Alright, so this limit or the 3 month limit of the age that had been struck down, and ultimately Supreme Court said that this is arbitrary as well as discriminatory in nature. Alright, then comes the Christian conversion case. In this, the Supreme Court have reaffirmed that if any person gets converted to Christianity, so he automatically extinguishes his Supreme Court status, as it is in the 1950 order that it is limited that the scheduled caste they can convert to Hindus, to Sikh and the Buddhist only. Alright, so ultimately if a person is getting converted to Christianity, his SC status will get lost, and that is what the about right to safe travel, that is under Article 21, and here the Supreme Court have declared that the safety from road accidents on highways, it is a fundamental right. And by moving ahead, Supreme Court have said that or ordered that there should be removal of the unauthorized eateries in the highway zone so that the life could be protected, and there is a right to safe travel. That is, again, it was said that it is inferred under Article 21, that is right to life. Then comes the bulldozer justice of 2026. Now when it comes to bulldozer justice, we have seen that the government have used the bulldozer for demolishing various of the houses that were there of the miscreants. Over here, the Supreme Court have emphasized that the demolition without due process, that is without any FIR, without any notice, that violates the right to property as well as the rule of law. So this connects directly to the Article 300A, where the right to property is now a constitutional as well as a legal right that is available to the citizens of India. The next is about the apnea test scrutiny. Alright, when it comes to apnea test, it is very important test when it comes to determining if a person is brain dead or not. So over here, Supreme Court have said that the examining if the apnea test is used for the brain death is inconclusive. And at the same time, it said that there is a potential that the apnea test in itself, it could induce the brain death to the person. So therefore, this should not be used, and this was clarified by the Supreme Court. And then there is Corbett Tiger Reserve case, in which the Supreme Court have directed the restoration of the felling sites and also institutionalized the Central Empowered Committee or CEC as a permanent body in the Jim Corbett National Park. The next is, the next one is about the Waqf Board composition. In Waqf Board composition, the Supreme Court have capped the non-Muslim membership and recommended that the CEOs should be Muslims. It highlights that the state has a secular regulation of the religious trust that should be maintained. The next important act is the Summary Judgment Order 13A. Over here, the Supreme Court have established the guidelines for the summary judgment in the commercial suits which are there to bypass the long trials when the defense is fanciful, and that was what had been laid down by Supreme Court. Then comes the adoptive mother maturity. So I have already discussed that it has struck down section 60 clause 4 of the Social Security Code by placing, or that had placed, the age limits on the adoptive children. So there was an age limit of 3 months, and that had been struck down by the Supreme Court. Then is CP Francis versus CP Joseph. This is where the Supreme Court have ruled that the family relations or any frictions which is there between the family, they do not invalidate a will. The testator's intent is the supreme consideration that is taken into consideration while deciding whether the will is right or wrong, that had been laid down by the Supreme Court. And also there is TSL PRB versus Penjarala Vijay, over where the Supreme Court have said that the license renewals operate prospectively only. That is, when the license get renewed, so prospectively only afterwards you can start doing the work that you are doing, and past unauthorized operations, they cannot be regularized by the renewal of the license, and that had been laid down by the Supreme Court. So these are the again important cases, and also there are few more cases that are important that happened in the Supreme Court in the past 1 year. The one is Property Owners Association versus State of Maharashtra. In this 9-judge bench, they have unanimously held that the Article 31C, that is, which protects the laws advancing the directive principles of state policy which are given under Article 39B and 39C, they continues to exist even after the Minerva Mills case. Alright, and 8:1 in the ratio, they held that not all the private property that is there, it can automatically be a material resource of the community. Only property that meets the specific criteria, that is availability, nationalization potential, etc., they qualifies as the material resource of the community, and thereby over here the Supreme Court have barred, or it has settled the long pending question on the scope of the acquisition power that the state has. The next important case is Pankaj Bansal versus Union of India. In Pankaj Bansal versus Union of India, again very important, it had laid down that the UAPA, that is Unlawful Activities Prevention Act. Now this is a Preventive Detention Act. This is Preventive Detention Act, or you can also say that this is an act that is linked to terrorism. Alright, this is Unlawful Activities Prevention Act. So Supreme Court have said that even those arrestees who had been arrested under UAPA, they must receive the grounds of arrest in writing. Now we know that there is the protection that is available in the terms of or in the context protection, it was there before. So this changes everything, and here it has said that constitutional mandate is from the Pankaj Bansal case that the grounds of arrest in writing applies equally to the UAPA arrest as well. Alright, or the Unlawful Activities Prevention Act. And when it comes to Article 22(1), rights. So the right to be informed on the grounds of the arrest and to consult a lawyer, they are also available for the people who have been arrested on the preventive grounds, and they are inviolable, that had been laid down by the Supreme Court. The language accessible to the arrested person is mandatory, and also it expands the protection of the personal liberty under Article 21 and 22 to the anti-terror law. Again, very important because it extends the rights. The next important judgment is about the bail conditions which cannot violate the right for privacy. Alright, what had happened was there were certain of the bail conditions that were laid down, and over here it was asked that the accused should drop a pin on the Google map, that where he is going, or so that the police can access, and this Supreme Court said that this amounts to the continuous surveillance, and this continuous surveillance is basically violating the right to privacy. Alright, that is there under Article 21. So this has expanded the Puttaswamy judgment or the right to privacy into the bail jurisprudence as well. It checks the arbitrary bail conditions and protects the personal liberty during the trial. So it is said, or the Supreme Court said, that the bail conditions, they must not be freakish and must serve the administration of justice and not punishment. The next important case is about Madras Bar Association versus Union of India. This is about the Tribunal Reforms Act, and over here the Tribunals Reforms Act of 2021 had been struck down. Now the Constitution Bench, it had struck down the act, and it had held that substantially reproduced version of the Tribunal Reforms Ordinance that was there in 2021. So there was this ordinance which was, or which has already been struck down. Now what the government or the parliament did, that it circumvented the complete ordinance, and it introduced another act for the complete process. So over here the Supreme Court said that the parliament, it cannot circumvent the Supreme Court's constitutional ruling by reenacting the struck down provisions. Alright, so again this reaffirms or affirms the judicial review as supreme and as the basic structure of the constitution, and prevents the legislative bypass of the Supreme Court rulings as well. It reinforces that there is separation of power and protects the judicial independence of the tribunals also. Now, the next important act that was, or the case that was there, it was Ravindra Pratap Shahi versus State of UP. Now, in this, the Supreme Court have addressed the chronic issue of delayed pronouncement of judgments even after the hearings have been concluded. So, after the hearing had been concluded, the courts, they delay the pronouncement of the judgments, and here the Supreme Court have said that there should be, or there should be a established structured reporting and escalation mechanism, and also it said that the reaffirmed principles are there from the Anil Rai versus State of Bihar, which had been already laid down by the court. So there should be a timely justice, which is an inseparable phase of the Article 21, and Article 21 is a living right, including the right to timely adjudication of the courts as well, or of the different, that is there. Now, there were also various environmental Supreme Court orders related to sand mining as well, especially when it comes to Chambal. Alright, there was a case about Chambal as well, where the Supreme Court have said that do we need to provide, or we need to, execute, or we need to see that there have to be a central police force that have to be stationed there, and ultimately we will stop the sand mining from that particular region. Now, there had been lots of cases related to sand mining, and the Supreme Court have led a comprehensive guideline for preventing the illegal sand mining, which is being done from the riverbeds, including the man-made water bodies which are there. Alright, it has also extended the environmental protection to the artificial reservoirs and ponds as well, and had directed the states to strictly enforce the regulation and create a complete oversight mechanism. Now, when it comes to sand mining, this is very important threat that we have right now. Illegal sand mining, it is a major environmental as well as governance issue because it affects the complete morphology of rivers. The groundwater recharge as well, and the flood patterns are also changed because of the sand mining operations. Now, at the same time, Supreme Court have also ordered the Jharkhand government to declare the Saranda forest as the wildlife sanctuary, so that the biodiversity could be preserved in the region, and also the illegal mining can be protected over here. Now, when it comes to Saranda, Saranda is the one of the Asia's largest sal forests that are found over here, and also it is a critical elephant corridor as well. So again, this links with the T.N. Godavarman case, because when it comes to the forest definition were provided by the court in the T.N. Godavarman case, in which it said that the forest is not limited to the areas where we have forests which have not been notified by the government, they will also be deemed to be forest. Now the next one is about the medical emergency or the golden hour. Now in this case, the Supreme Court have held that denying any timely medical treatment during the golden hour, this is the first few minutes or the first few seconds which are there, which are critical for saving the lives. So that violates the right to life under the Article 21. And the Supreme Court said that the state has a positive obligation to see and to ensure that the emergency health care is accessible to the people, and the hospitals, they cannot turn away the accident victims as well. Now, this says that the state have a positive obligation which is there under Article 21, under the directive principle of the health, that is Article 47, that lays down that the state must regard raising the level of nutrition and improving the public health as well. So these are the crucial obligations which were touched upon by the Supreme Court in this judgment. Now the next important judgment is the KP Tamil Maran versus state, and this is about the honor killing. Now there was an honor killing in Tamil Nadu, and over here Supreme Court have delivered this landmark ruling upon the honor killings, and it had clarified that the evidentiary value of the hostile as well as related witness is very important. Alright, it has said that there were intercaste couple which were there. Alright, the couple were Murugesan as well as Kannagi in Tamil Nadu. They were murdered by the bride's family in 2003. So ultimately, through this particular judgment, the Supreme Court have strengthened the conviction standards for the honor killing cases in India. Again, this is important for honor killings. The next important case is the Sohail Malik versus Union of India, and in this case, Supreme Court have held that the ICC, that is Internal Complaints Committee. Now, this Internal Complaints Committee is under the POSH Act. POSH Act is basically, again, very important because it is Prevention of Sexual Harassment Act that is there. It is for the various, acts of the sexual harassment that had been prevented by this in the workplace. So, the ICC or the Internal Complaint Committee under the Prevention of Sexual Harassment Act that can conduct the preliminary inquiry, this was laid down by the Supreme Court even if the respondent works in a different government department. So ultimately, it expands the scope of the workplace sexual harassment inquiry under the POSH Act of 2013. So again, it connects with the Vishakha guidelines as well. You could be asked about Vishakha guidelines even about this. Alright, so that would be all in this video. These are the important landmark Supreme Court judgments. We have discussed the historic, even the current judgments which had been passed by the Supreme Court. Now, if you are preparing for the UPSC 2027 and 28 and you are looking for a better optional for you, so public administration provides you with that benefit. It is a better optional that you can have, and ultimately when it comes to public administration, I will be taking the optional classes right from 15th of May, and you can enroll into the batch by using the code BRSLive for the maximum discount. Also, we have the UPSC GS Foundation batch for 2027 and for 2028, that is Resolution P2I batches. You can enroll into these batches. The batches will be starting from the 7th of May. And again, you can enroll into these batches using the code BRSLive for the maximum discount. So that would be all in this video. Thank you everyone for being over here with me, along with me, and going through the important landmark judgments of the Supreme Court that could be asked in your examination upcoming prelims 2026. And they are not just important for your 2026, but also if you are preparing for 2027 as well, because they connect the previous landmark judgments to the present judgments or the present case decisions which had happened in the Supreme Court. So that would be all. Thank you very much, guys, for joining me over here. I'll see you in the next video, in the next session tomorrow. So till then, take care of yourself and bye-bye.